State your name for the record, please.
Dustin Duncan.
All right, Your Honor, thank you for recalling this matter. So based on Mr. Duncan's appearance, I would ask the court to withdraw the bench warrant.
What was his name? There's a bond by.
Yeah, no, I see it. I got it. Don't worry. Is it 25? Well, you see the violation. The violation was the reason that I issued the warrant in this case.
Right, Your Honor. I've discussed the bond violation with Mr. Duncan. And Your Honor, to his credit, he did contact his community corrections agent and admitted.
When did he do
To
that?
consuming alcohol. The report indicates that he did, or it may have been the email actually that was sent out by Mr. Casey, where it indicated that Mr. Duncan did call him and admitted to drinking a twisted tea on September 13th, which is what ultimately led to the positive test on that date.
But
And then obviously we do have other issues. I'm aware of that, but at least he did admit to consuming alcohol to his community corrections agent. I can tell you that based on my discussion with Mr. Duncan, he has started attending some meetings with the Alano Club. He has reached out to Home of New Vision. He's an admitted alcoholic, Your Honor.
Right, Pickett.
I understand all of that, but my other problem is that given the other sort of missed test, I mean, what about on, you say the twisted tea on the 13th, what about on August 30th? What were you drinking then?
Same twisted tea, Your Honor. I've contacted Home and New Vision. Can I speak?
I just said that, but you're welcome to say it if you'd like to.
No, I didn't. I start talking. Contacted Mr. Leroy Pickett with Home and New Vision for a sponsor. I had 4 years clean and I relapsed. I know firsthand I need help with it.
Well, I understand all of that, sir, but so here's part of the problem that I'm having. Not only is there then these tests, he also has then missed tests, of which I would have to assume you're drinking.
Yes, I
So
was.
I'm going to ask you this, all right?
Okay.
I have a bunch of missed tests. But on August 30th, I have the alcohol shows up. On September 13th, alcohol shows up. And we have more
The courtroom doors open, and the defendant walks in with an unsteady posture, trying his best to look normal but failing miserably. His red eyes, shaky hands, and sluggish movements immediately catch Judge Simpson's attention. Before the hearing can even begin, the judge questions why the man appears impaired. The defendant nervously insists that he just didn't sleep well, but his slurred responses say otherwise. The judge orders the bailiff to verify his condition, and the entire room gets tense as everyone realizes something is seriously off. Judge Simpson warns him that any dishonesty will make things worse, setting the stage for a dramatic confrontation.
This test. So between, I guess, the 16th, the date of this report, and the date you went on the tether back in August, how many times have you drank?
6 or 7, maybe
Yeah.
8. I had 2 missed tests. I was in the hospital, but I did. Yes, I did.
You just are continuing to consume alcohol. And you're playing with the testing so that it appears as though it's just a missed test, when in fact, what it is you're drinking. And you really, quite frankly, need to go inpatient. I mean, you know you can't do this on your own.
Correct.
Mr. Bowling.
Your Honor, Mr. Duncan is the sole care provider for his 95-year-old mother. I don't necessarily disagree with what this court just stated, and I don't think Mr. Duncan does either. Would the court consider allowing him to be put onto a scram tether pending getting into an inpatient treatment facility?
It's the reality is in this type of circumstance, that doesn't help.
If nothing else, maybe it would be a reminder with a device on his leg that maybe he needs to call a sponsor if he feels like he needs to drink, or that he needs to attend an online AA meeting at any time of the day. Maybe the tether on his body would give a little bit more reminder than the sober link sitting on the nightstand table or the couch side table.
People have some concerns if you'd like to hear.
Yes, go on.
Well, the allegations include that Mr. Duncan was highly intoxicated at the time, walking into traffic, wielding a knife, trying to punch cars, making statements to incite a fight, continued that type of behavior when police arrived to take him into custody. My point in that is he was highly intoxicated during these felonies. So that's certainly a concern if he were to be released, even on a scram tether. At most, I would think the court could maybe consider a release to long-term inpatient treatment if you were to take him into custody. Thank you.
To adjourn the defendant's probable cause conference to September 30th, 2025, 9 a.m. And at this time, given the violations, defendant's bodies.
Thank you. I'm sorry, you said September 30th? 30th.
Mark Ellis, representing Mr. Jolly, who stands to my right. Please tell the judge your name.
Randall Jolly.
All right, go ahead.
Your Honor, we have been offered a plea bargain. We wish to take advantage. We have signed the forms.
But does he have a medical marijuana card?
Yes.
All right. And the other, why did we get another violation report? Because I think we went through this before.
Yeah, it's actually a progress report. He has a prescription for exactly that drug. So
I know what it is. His healthcare provider hasn't provided anything.
yes, he has sought that and it hasn't been given to him yet. He has asked for that. And we apologize.
Well, but my problem is he's telling me that's what he's on. He's telling me that, but I
Yes.
don't have anything from a healthcare.
As the case is presented, the defendant keeps interrupting with excuses, claiming he only had one small drink hours ago. Judge Simpson, maintaining complete control of the room, pulls out the official arrest report. In a firm, calm tone, he reads out the defendant's blood alcohol content, which is shockingly high. The judge asks why the man continues lying, reminding him that the court values honesty above all. The defendant grows visibly uncomfortable, stumbling over his words. The judge's sharp questions expose every contradiction, leaving the man speechless as the courtroom watches in silence. Clip
It to you.
Well, then we've got a problem. I mean, he can actually he can get some of that information potentially from his pharmacist in terms of whether or not there's a valid prescription. I mean, they want information from medical care provider that he indeed has a prescription.
Okay.
That has not been given. It wasn't here entirely at the last hearing, and I didn't remand him. But
We
now I'm
appreciate that.
here. I still don't have it. I still have what looked like dirty tests. You're telling me that he's got a doctor's prescription. I just don't have it.
My understanding is the only way you get a prescription bottle that says a drug on it is you go to the pharmacy and they give it to you.
Give me a computer, I'll make you one. Or one that at least looks like it.
We'd be happy to supply if a note from his pharmacy is adequate to the court.
Well, something that just indicates that there's a prescription. That is a valid prescription for this
Understood.
narcotic.
Take a bottle.
Oh.
A bottle can be plagiarized, so to speak.
And I will then, this probable cause conference, how long will it take you to do it? Can you get it done by the 30th?
Absolutely, yes, sir.
I'll adjourn this matter out to September 30th, 2025 at 9 a.m. Correct? 30th. No. You can't do. Oh, yes, I can. At 9 a.m. That's a split day.
That is fine, Your Honor.
Yes.
Thank you.
Okay. Bond will continue.
No,
Thank you.
Your Honor, thank you.
Thank you.
Anita Barnes.
Brown King on behalf of Ms. Barnes, Your Honor.
What are we doing?
I'm requesting adjournment.
May I say something, please?
Well, we're in court.
Can you what?
She wanted to
May I
talk to
say
me, but
something, please? No, I mean to the judge, to everyone. May I say something?
Go for it.
I would just like to say that I feel quite a bit of confliction here. I am still not very clear on why I'm even in court, and my attorney keeps getting changed, and it keeps getting adjourned, and no one's in
I'll tell you,
communication.
ma'am, I'm going to stop you if you're worried about the attorneys getting changed and communications there. We can solve that problem by having you come down. I'll hold your file today.
Defendant tries one last time to justify his reckless actions, saying he didn't think he was that drunk and believed he could safely drive. This pushes Judge Simpson over the edge. He launches into a powerful, emotional lecture about the dangers of drunk driving, how innocent people get hurt, families get destroyed, and lives end because of irresponsible choices. His voice echoes across the courtroom as he reminds the defendant that his decision could have easily turned deadly. The defendant's expression shifts from defensive to defeated as the judge forces him to confront the reality of his behavior. Clip 4.
Okay. And then you'll be able to get a clear understanding from me directly as to what you're charged with. I don't mind going through an arraignment again, and then you can talk in detail with Mr. Brown if that's what you'd like to do.
I just would like for someone to be able to reach a little bit more out to me. I'm struggling with my transportation right now. I don't have the means for Uber, and my living situation isn't the best. I'm in a hotel, and I'm just trying to make sure I'm as clear as possible with everything that's going on as well.
Okay, I understand your concern, and I'm sure that the Public Defender's Office does everything they can to communicate with you. It sometimes can be difficult when the client doesn't appear here and is requesting to appear via Zoom, because even the conversation on this day can't happen. So if what you'd like me to do, given the adjournment, is set it the next hearing, if you don't believe that there's communication, I'll make sure the two of you get together, because I'll demand that it be in person and you'll have to be here. If that's what you'd like me to do, I'll be more than happy to do that.
I don't mind trying to set it up beforehand, but honestly, I just started a new job and things like that. As long as it's far enough for me to actually be able to make it, I would like to show my best appearance to be a part of these things. I don't mind. I just haven't had the chance to.
What do you want me to do?
And, Judge, anything that you find worthy, I appreciate being able to show up Zoom. But if the problem is me being here by Zoom, I will try my hardest to make it there. I just don't want to get in trouble because I couldn't make it there.
Mr. Brown, what do you want?
pardon me?
What do you want me to do? I don't understand what you want me to do, ma'am.
I'm requesting adjournment on her behalf, but I'll be here till 4 o'clock. She wants to come on down. I'll be happy to talk to her.
You hear that, ma'am?
Yes, I did.
Mr. Brown is very dedicated. He'll be here till 4 o'clock. All right. So if you
Okay.
if you're worried about communication and something, he will make himself available.
Okay, thank
All
you.
right. So you coming?
I will try my hardest. If I'll call the prosecutor's office to get your information so that I can
How-
contact you.
How about we just adjourn it and we set a meeting where you come to my office?
That would be the
No,
best.
no,
thing for
she
me.
should come down here by 4. You'll be here.
Oh, okay. the
I
judge
can't guarantee
ordered me
that I can be there by 4. I have to get my daughter from the bus stop at 4:17 exactly. And I have to figure out if anyone can give me a ride out that way first. I don't have a vehicle.
All right, I'm gonna let you guys work it out.
I'm just requesting adjournment, John. That's all.
Probable cause conference will be adjourned. I'll give you guys time to try to work this out. October 9th, 2025, 9 a.m.
You want my number again?
Yes, please. I do not have it.
222-6970.
Okay.
Okay, I'm on it. Thank you.
Okay.
All right. Bond will continue.
Judge Simpson delivers a final ruling. His tone is strict, uncompromising, and direct. He lays out the consequences one by one. Fines, mandatory programs, possible jail time, license suspension, ensuring the defendant understands the seriousness of what he did. The judge tells him that this courtroom will not tolerate reckless drunk behavior under any circumstances. The defendant stands frozen, realizing the full weight of the punishment. As the gavel comes down, the entire courtroom remains silent, witnessing Judge Simpson's firm stance against dangerous and irresponsible conduct.